Mr. President,
Senator from New Jersey.
I ask that the quorum call be vitiated.
Without objection.
Thank you. Mr. President, I've come to the floor to speak on the nomination of Congressman Price to be the Secretary of Health and Human Services. But before I do, I must speak to the decision that the United States Court of Appeals for the Ninth Circuit just decided in the case of the state of Washington and the state of Minnesota versus the President and the Department of Homeland Security. And I am pleased to see that the courts of the United States are still part of the separate co-equal branch of government that the founders dictated when they ultimately created an ingenious document through the Constitution of the United States that has served the nation well for so long. And even though it seems that the President may need a review of history and an understanding of the Constitution as it relates to the separate co-equal branches of government, because he seems to be willing to try to disparage the judiciary as an effort to try to either affect their decision-making or to call into question the legality of their decisions or the righteousness of their decisions. I'm glad to see that that has not affected our judicial system. I just want to read from some elements of the court's decisions, which I think are pretty extraordinary. Of course, this is far from a final decision on the merits, but it was on a motion for a stay of the order of the district court that said basically the Muslim ban could not be continued to be enforced. The court said, and I'm quoting from them, in a unanimous opinion, which speaks very powerfully to their decision, we therefore conclude that the states, meaning the states that brought forth Washington as well as the state of Minnesota, that the states have alleged harms to their proprietary interests traceable to the executive order. The necessary connection can be drawn in two very logical steps. One, the executive order prevents nationals of 7 countries from entering Washington and Minnesota. And two, as a result, some of these people will not enter state universities, some of them will not join those universities as faculty, some will be prevented from performing research, and some will not be permitted to return if they leave. We therefore hold that the states have standing, which was one of the critical legal bars. Secondly, they opined on the reviewability of the executive order, and this is, I think, extraordinarily important. The court went on to say that yes, and I'm paraphrasing at this point, that yes, the courts owe substantial deference to the immigration and national security policy determinations of the political branches, legislative and executive. But it went to further to say, quote, this here I'm quoting, instead, the government has taken the position, this is on behalf of the executive branch, that the President's decisions about immigration policy, particularly when motivated by national security concerns, are unreviewable. Unreviewable, even if those actions potentially contravene constitutional rights and protections. Even if those actions potentially contravene constitutional rights and protection. The government indeed asserts that it violates separation of powers for the judiciary to entertain a constitutional challenge to executive actions such as this one. And I didn't really had captured that the government had made that argument, but that's an extraordinary argument. The court went on to say, and I quote, there is no precedent to support this claimed unreviewability, which runs contrary to the fundamental structure of our constitutional democracy. Within our system, it is the role of the judiciary to interpret the law, a duty that will sometimes require the resolution of litigation, challenging the constitutional authority of one of the 3 branches. We are called upon to perform that duty in this case. Further, they say, and I quote, although our jurisprudence has long counseled deference to the political branches on matters of immigration and national security, neither the Supreme Court nor our court has ever held that courts lack the authority to review executive action in those arenas for compliance with the Constitution. It's an extraordinary set of statements that the government made, saying that the president's actions are unreviewable in this regard. They further go on to say, and I'm quoting again, nonetheless, courts are not powerless to review the political branch's actions with respect to matters of national security. It would indeed be ironic if, in the name of national defense, we would sanction the subversion of one of those liberties which makes the defense of the nation worthwhile. Well, I fully agree with the circuit court's the determination in that regard. And it goes on to say, in short, although courts owe considerable deference to the president's policy determinations with respect to immigration and national security, it is beyond question that the federal judiciary retains the authority to adjudicate constitutional challenges to executive action. Well, all I can say is thank God. Thank God that the courts of the United States feel that they are not controlled by the executive branch in pursuing the decisions that are made, and this is a great day for democracy in our country and for the preservation of the separations of powers. And great day, I think, from my own perspective, that a ban that does not help the United States but harms us and is against every fiber of our being and the nature of the history of our nation, which was founded by those fleeing religious persecution. Ultimately, today, we restore that sense of our history, and we restore who we are as a nation, both at home and across the world. But today's decisions in this regard are also important as we consider the nomination of Congressman Price.